I wanted to welcome everyone. It is July 29th, 30th. It is July 30th, Tuesday morning, 2024. We are here on CBA case number 24-030 in the matter of Greenspring Joppa Falls LLC, the owner and developer of a development known as Greenspring Manor at 2310 West Joppa Road. Today's deliberation involves only the development plan, not the zoning prong of a case where they were originally combined in a hearing before the administrative law judge, who last July denied the combined development plan and zoning petition in September. The administrative law judge granted a motion for reconsideration. And in April of this year, the ALJ issued an amended combined development plan and zoning opinion in order after the motion for reconsideration hearing. And in that order, the development plan was approved subject to conditions. In June 11th, we had a hearing in which we bifurcated the case between the development plan and the zoning issues and heard argument over first whether we felt the ALJ had the discretion to grant the motion for reconsideration and hold a hearing. At that time, we held that the ALJ's discretion was broad enough to grant the motion and convene a hearing. That is not to say that we dealt with any of the issues that arose during that hearing or reached any conclusion as to the legal issues. But once we held she had the discretion, we heard the argument on the development plan, and subsequently council submitted memoranda raising numerous issues. And we are here now to address the issues before us. Under the code, if you'll bear with me just a minute, our authority is limited by Baltimore County Code 32-4281, which addresses appeals to the Board of Appeals. Actions by the Board of the Appeals, we can remand, affirm, or reverse or modify if the ALJ decision exceeds the statutory authority or jurisdiction, results from an unlawful procedure, is affected by any other error of law, is unsupported by competent material and substantial evidence in light of the entire record as submitted, or is arbitrary and capricious. So we're limited in many ways. There were a lot of issues raised at the hearing before us. The first had to do with the protestants, the protestants raised that the testimony and evidence that was heard at the motion on reconsideration, whether or not it was admissible. That included the letter from the county attorney, Mr. Benjamin, and the testimony of Mr. Bayer from the Department of Public Works. Another issue that was raised was whether the ALJ exceeded her authority in granting the amendment to the plan, or whether that was not permitted for any other reason. Mr. Wyatt, I believe, raised some due process issues. Mr. McCann raised issues regarding shifting of the burden from the developer to the appellant in the hearing on reconsideration. There were numerous issues involving the facts for the condition of the sewer, public sanitary sewer serving the property, and whether it could lawfully, if it was lawfully in a adequate to handle the capacity from 61 new residences. Were there any other issues either of you identified that I have perhaps overlooked?
There are so many issues that maybe it's possible that we might have, but I think that's the gist of it.
That's going over my sheet. He looks like he touched base with just about all, but there was quite a few of them.
And what we are not discussing today is traffic, just to make it clear. So I guess the first thing I would raise is the county attorney letter. And in my view, because it's an administrative proceeding, I believe the ALJ, the administrative law judge, had the discretion to admit the letter. I do not personally see that it had any probative value, because we talked about, without producing any documentary evidence, ongoing negotiations, which, you know, is just, to me, just talk. So I don't think it had any probative value regarding the sewer line. I think that the ALJ did rely on the information in her amended order, almost to the extent of taking judicial notice of it as some sort of judicial fact, which it clearly isn't. So I'm not sure it was error, but I think she had the right to admit it. I don't think it has much value. I don't think she should have relied on it in reaching her decision, but that's where I am on that issue.
Yeah, if I may, I think I absolutely agree with you, especially with respect to the issue of what was the probative value of the letter. And can, in the manner in which it was relied upon for the amended opinion. And I think I would go so far as to say that because of in light of the entire record, when you take into account how thorough the original opinion is, and this additional piece of evidence is used to turn the entire opinion, practically, but that the evidence itself, I think, has very little value. I mean, essentially, it says maybe one day we might come to some agreement to do a thing, with Johns Hopkins that we didn't hold them to the first time, and now they no longer have any obligation. And this may not be determinative, but the issue of the Benedictine sisters essentially can veto the whole thing if they want to, because it runs to their property, unless they choose to, or the county eminent domains the land. I guess I don't. But I do think that constitutes, a material error, or essentially that it creates a situation where the amended opinion is no longer supported by the competent material evidence in light of the rest of the record that was already created up until then.
I find the exact same way, that the letter was due in, but the lack of supporting of it compared of the evidence that was already presented is not enough.
So we agree that the letter has no probative value. Do we believe that her relying on it was an error
I don't
that
know.
affects the rest of the opinion?
I think it does, because it's entirely relied upon. That the effect of the opinion was entirely altered by it.
Okay. Well, let's move on to Mr. Bayer's testimony. Should Mr. Bayer have been allowed to testify, and was what he testified to, was it new evidence, or is it evidence the developer should have been able to produce in the 12 or 13 days of hearings that preceded the appeal? He was somewhat evasive as to when he obtained all this information as to what he knew and when. So I was wondering if you looked at that.
I didn't really consider the issue of what he knew and when. I mean, I guess it feels strongly like sort of post hoc, kind of going back and filling in blank spaces that were not filled in originally, or maybe whiting some things out, starting over again. But yeah, I'm not really sure how that interplays with the issue of the ruling we made last time we sat down, which was it okay to hear it to begin with, and then if it's in the judge's discretion to hear it, is it okay that it's additional evidence at that point?
Well, and she also has the discretion as to what weight to give that testimony, and she clearly, even absent Mr. Benjamin's letter, gave Mr. Bayer's testimony a lot of weight over continuing objections.
The letter came at a very critical time for the department to feel that this letter had that much weight not to be presented earlier in the case. I do not feel that the evidence support that letter has this much weight. But because the letter came so late, someone felt that this letter held a lot of weight.
What do you think about Mr. Bayer's testimony?
I felt like it was vague to a degree.
It was what?
Vague.
Vague.
Yes, and not supportive of enough evidence to make it hold enough weight, I feel.
Mr. Stelmack?
So,
I mean, in a roundabout way, I agree with Mr. Palashuk there, and I think again, setting aside the issue of procedurally, whether there were procedural issues or due process issues with respect to the actual testimony, was it the actual testimony enough to ultimately change the opinion? And I think the ultimate answer to that question is no. I think that the original opinion was so strongly thought out and so supported by evidence that, and I guess the question is am I substituting my judgment for the ALJ's judgment? But in this case, I just, I don't think there was enough there to change the ultimate opinion.
I'm sorry, I didn't get that last.
I said I don't think there was enough there to change the ultimate opinion. I don't think there was enough evidence brought in to do a complete ultimate 180 on the way the case ultimately came out before the ALJ.
I'm not sure I agree, but I had procedural issues in the way things were handled with Mr. Bayer that go to whether it was enough or not, because though she did allow cross-examination, she did not give protestants any opportunity for rebuttal. And I think under the body of administrative law that I've looked into, there is a consideration of fundamental fairness that protestants should have had the opportunity to rebut that new testimony and evidence. And that would perhaps have allowed their experts to focus on Mr. Bayer's testimony and help clarify that in terms of whether it was sufficient evidence on which to reverse the original decision. So I gather both of you feel that Mr. Bayer's testimony was not sufficient factually to for the ALJ to change her mind.
That's correct. And even like I said, setting aside the procedural issues that you're bringing up now, and I'm
But you see, here's my concern.
Yeah.
She is the fact finder.
absolutely, but I mean, I think that
It
you know,
takes a very strong I mean, so does are you saying that her decision in the amended order is unsupported by competent material and substantial evidence in light of the entire record? I mean, we're very limited here. If it doesn't fall into one of these permissible
I
actions,
understand.
and
We, after that hearing, we all felt, I felt, I don't want to say we all, but listening to you at this point, I felt there was a procedural issue with Mr. Bailey. And the timing was, using the word short, was not efficient for the protester. That's the way I felt as soon as that case was over. I know you guys brought it up in the hearing. I didn't want to redone what was brought up, but yes, there is that issue. It's concerning in fairness and all.
And I mean, I think that there's an argument to, remand the matter to allow the procedural issues to be remedied. I think that's within our power. I don't know how you feel about that. Or to, I think the Protestants have asked us to essentially modify the opinion by striking the amended order, and I think that is on the table as well. But I would like to hear whether that's one of those roads is the road you would be prepared to go down.
We have one other issue I want to go over, and that is whether the amended plan that was admitted as part of the order on reconsideration, I believe, eliminated the gate on Tally Ho Road between the proposed subdivision and the meadows. It sounds as though the developer is willing to put the gate in because the community felt strongly about it. Apparently, I think we have the right to reimpose that condition. Going forward, if we choose to. Again, the ALJ allowed no testimony regarding the gate. It was argued in the memoranda, but that was one of the other issues. So it would be my view that we deny approval of the amended plan and go with the original plan. The question is, how do you wish to deal with the amended order? We can remand. I personally do not like remanding cases because it won't change the outcome and it just delays resolving issues. But that's my personal view. We have the right to remand. We can affirm. And if we feel we are bound by the ALJ's factual findings, whether based, putting aside the Benjamin letter, but looking at Mr. Bayer's testimony, if we feel we are bound by her factual findings, we should affirm, at least as to the order, if not as to the plan. If we feel her decision was based on an error of law, including the procedural issues which we've talked about, or is unsupported by the evidence, or is arbitrary or capricious, we can certainly reverse. From a point of view of judicial economy, for Mr. Polchuk's benefit, if we remand, it goes back to the ALJ to address whatever issues we raise. It will undoubtedly come back to us on appeal from somebody. And then we will go through this exercise yet again, hopefully without having these issues before us. But they may be. If we reverse or modify, we can modify the ALJ order, for instance, by denying the amended plan, but affirming the order, or by adding conditions of our own, or we can reverse based on some of the issues we've talked about today. If we take the position of modifying or reversing rather than remanding, if anyone is unhappy with our decision, which I'm sure somebody will be, any appeal would go to circuit court. So it would eliminate a little bit of the back and forth. But we need to be able to support our decision. And I think we have enough issues that we could go either way with legal support. So having said that, you clear on our choices, Bill?
Yeah, I
don't
hear your opinion as we proceed, but yes, I do understand every one of the boundaries.
Mr. Stelmach, you with me?
I would be remiss if I didn't say that I am not 100% conceptually approving the order versus approving the plan. To me, it's all the same. So I'm not sure that I'm 100% with you on that as far as that goes.
Okay. That's why we do these deliberations.
Right.
So what I'm going to ask each of you is, would you affirm or reverse? If it is to affirm, reverse, or remand, if it is to remand, what issues do we want addressed? If it is to affirm, do we want to modify it all? Well, if we reverse, on what is the basis that you would reverse on? So I'm going to ask Mr. Stelmack. I'll tell you where I'm hung up on this, so you know why I'm putting you on the spot. These are administrative proceedings. The ALJ has broad discretion. I'm just not sure about the factual issues being whether or not we are bound by her findings of fact to the extent that she reversed, and whether or not what I will call procedural irregularities are sufficient to reverse. And I'd really appreciate your thoughts on those two issues.
I mean, it sounds to me that you want to allow the ALJ the discretion, even if there are procedural issues, to run her hearings the way she wants. And I respect that, and I think that that is important. So to the extent that you feel that way, I can go along with that. I think that from my standpoint, though, that even assuming that all the evidence at the later hearing was admissible and somewhat probative, I still don't see how it can overturn just the tremendous weight of evidence that is already in the original opinion. Just a huge body of weight of evidence. And to me, that is the amended opinion is unsupported by competent material and substantial evidence in light of the entire record. And I think that to the extent that the Protestants are asking that amended opinion be, I guess in a sense, withdrawn by modification on our part, I think that is the way I would go with it.
So you would reverse?
I would reverse the amended order and reinstate the original order.
And based on the evidence being unsupported. And Mr. Palchuk, well, wait, before we leave Mr. Stelmack, and would you find the Benjamin letter inadmissible or just give it no weight?
I think it's admissible on the discretion of the judge, but I think that it's meaningless.
Well, it was a discussion of it, and reliance on it was part of the amended opinion. And you're saying that's also unsupported.
Right.
Okay.
Yes.
Got it. Mr. Palchuk, would you remand, affirm, or reverse?
I believe, listening with Mike,
I
know the way Mike would go on this issue.
So you would reverse?
Yes.
I'm not sure I agree on all these points, but I will say that I would concur as to any part of the decision based on Mr. Benjamin's letter as being unsupported, because there's nothing factually there on which to say we're assured that these improvements are going to happen, clearly. So I would concur on the Benjamin letter. I would absolutely not accept the amended plan. I think there were due process irregularities that might be remedied by remanding, but I don't think that a remand is a good result. And I would certainly identify those irregularities in our decision, because I do believe that the protestants were not given the same opportunity as the developer. And I hear you loud and clear that the weight of the evidence was not sufficient to overcome the entire record. I'm less certain about that than you guys, but I will certainly concur in reversing on the basis of both your opinions, and reverse on the basis that the amended order was unsupported by competent material and substantial evidence in light of the entire record. And that would address both the county attorney letter, the sewer issues, and to some extent, the amended plan, because there was no opportunity to put on any evidence about that. Are there any conditions you think that need to go with this? I think reversal doesn't really require anything like that, but
No, I think the original order gets it right with respect to the gate issue.
I
don't know
agree.
if we have to deal with that specifically, but
I don't think we have to deal with it if we just reverse on all counts.
Okay.
Mr. Polchuk, any further thoughts?
Do you have any other strong opinions about the overall lining of the case? I do not. I do not.
none that are material or determinative to what we're doing here right now.
I'm sorry, I'm having trouble understanding.
I'm sorry, I'm mumbling. Not that are material to what we're doing here right now.
Right.
I think the attorneys have both done diligent work, and I appreciate their efforts.
Absolutely.
And I don't think this reflects on them if we find there was error below. So unless there is something more to be said, I will conclude this deliberation and stop the recording. Okay?
Thank you all.
Thank you.
Thank you.